Yes.
May I please your lordship? Sir, item number 9,
Yes.
daily list, my lord. Matter may be adjourned, my lord. In this matter, senior counsel PJ Soikia will appear, my lord. And today he is appearing before Kohima bench. So, my lord, some adjustment may be. My lord, any date of December, my lord.
We have already prepared
I know,
NDPS matter.
but paper book has not been made.
Lordship.
Okay, right, in the IA. Adjournment prayer has been made on behalf of Mr. PJ Saikia, learned counsel for the applicant / appellant. It is noticed that written objection has already been filed by the state. Accordingly, on the prayer made on behalf of Mr. PJ Saikia, list the matter
No.
after 2 weeks.
My lord, date may be fixed, my lord. December. Any date, my lord.
Give a date,
Yes.
after 2 or 3 weeks, whatever.
Lordship, since the TCR has been arrived, Lordship.
Then in the IA, in the main case, you write, as the TCR has arrived, registry to prepare the paper book.
Lordship.
May I
How
please-
blessed, Lordship.
may I please, your lordship? I pay for listing of a high criminal for bail, lordship. So this is pending since 2024.
If the bail application is pending since 24.
In
You mean the 430 BNSS,
No, no, no.
389,
Suspension, yeah, 15.
389.
If possible, on 9th or 10th.
Okay, 9.
Replay, please.
May I please your lordship? Lordship, I beg to mention an item from court number 5. It's item number 39. There is an urgency in the matter, so let it come on Friday, if possible. The
the
bench is
matter
the
about?
big one. Lordship,
What is the matter about?
an FT matter,
FT matter.
yes.
Okay. What is the urgency?
Sorry, Lordship.
What is the urgency?
Actually, the police has been searching for me.
So,
So an IA was filed because there was a typographical error in the synopsis. The matter was listed before and only.
so you are right now in hiding.
I don't know, Lordship.
You're not in hiding.
The police has been harassing actually. So let it come on Friday if possible, Lordship.
We'll see. We'll see.
Or else Monday.
Monday.
Much obliged, Lordship.
Maybe, my lord. I'd beg to mention item number 14, my lord.
Yes.
My lord, short accommodation is up for today. I have some
Why?
personal difficulty today, my lord.
What is the difficulty?
My lord, any day, maybe day after also is fine.
Why?
Actually, there's a medical appointment I have to go for, my lord, for my daughter.
You have to go.
Yes, my lord. I have to go in.
Okay, right.
I apologize, my lord. Otherwise, I would have circulated honestly.
Adjournment prayer has been made by the learned amicus on the ground that he's got a medical appointment. And this is the matter. After the week.
Obliged, my lord.
Lordship, I beg to mention item number 15. Lordship, I am appearing on behalf of Mr. Anjeda.
Okay, right. On the prayer for adjournment made by Mr. N.J. Das, learned amicus curiae, which has not been objected to by the learned APP. This is the matter. After a week,
After 2 weeks, Lordship.
after 2 weeks.
I think my lord, item number 16, my lord.
Yes.
16, 17 and 18, Lordship.
Yes.
The Cebu Paul. Earlier it was done by Bhuya, MS Bhuya, Lordship. So that juvenile issue was also there, Lordship. That was settled, Lordship. Now they will, tomorrow she will appear and tomorrow, Lordship.
My lord.
Tomorrow not possible. Tomorrow we are DP rising at 1.
Day after tomorrow, my lord, if possible, my lord. They all pending matter, my lord.
Huh?
No.
Huh?
মঙ্গলবার মানে রিডিও নহলে আপনি নয় বলছি 2 তারিখ
Tuesday,
second December.
Okay. This is a matter on 2nd December on the prayer made by the council for the party.
Thank you.
It's a jail appeal, Lordship. Amicus curiae has to be.
Okay, right. This is a jail appeal. against the judgment dated 21/7/2025 passed by the learned Sessions Judge Biswanath Karyali on 21/7/2025 in connection with Sessions Case number 1832/2016, by which the appellant has been sentenced to undergo rigorous imprisonment for life under section 302 IPC. Admit the appeal. Call for the TCR. Miss S.B. Bora, S.R. Bora,
H for us.
H. Bora. APP accepts notice on behalf of the state. This is the matter after 4 weeks.
Amicus curious.
Marcus, who?
So there is a list.
There's no matter, you deny. Who do you think?
LDB Lordship, MSLDB,
Huh?
MSLDB
MSL Devi.
Lordship.
She's here.
She is not
No,
there.
no, I mean, yeah. In the list.
I think she's there in the list. Legal aid.
Legal aid. No, this is amicus. Okay, you want from the legal aid.
She is there, another. B Sharma is. there.
Wait, let us give some new ones also. LDB is the legal aid council.
Lordship.
How many years,
Lordship.
how many years experience?
There is junior lordship. Ranjit Chand.
Okay,
Junior.
good. Okay, Miss L. Devi is appointed as the legal aid counsel for the appellant. Registry to inform her of the same. This is the matter of 4 weeks.
Same fair lordship.
Wait, let us see the case number and all. This will be a problem. This is a jail appeal against the judgment it dated 11/7/25, is it? No, wait. Dated 8/7/25. Passed by the session judge Shipsagar in sessions case number 66 bracket S-S bracket close of 2023, comma, by which the applicant has been convicted under section 302 IPC. Same, huh? Then out here, who do we appoint?
B Sharma.
Ms. B. Sharma, legal aid.
Abacus.
Is appointed as amicus.
Item 3.
So jail appeal.
This is a jail appeal filed against the judge, impugned judgment impugned judgment dated 8/8/25 passed by the court of the additional session judge cum special judge bracket POXO Ipsagar in special bracket POXO case number 18 of 2024 arising out of Sagar PS case number 62 of 2024, comma, by which the appellant has been convicted under section 376 bracket 3 IPC, arrayed with section 4 bracket 2 of the POXO Act. Good stuff. What? Come to page, come to this. one. Okay, good stuff. The appellant has been acquitted under section 363 IPC. Full stop. He has however been sentenced under section 4(2) of the POCSO Act. Full stop. Admit the appeal, call for the TCR. Issue notice returnable in 4 weeks. Miss S.H. Bora, additional PP accept notice on behalf of the state. Who do we appoint amicus?
Lordship U Chaudhary, Mr. U Chaudhary.
Mr. U Chaudhary is appointed the amicus curiae. So stop. Then that Miss S. Sharma, you give her, will no point. Miss S. Sharma, that's what Sharma is appointed as the legal aid counsel for the respondent number 2. List the matter. After 4 weeks. You told it.
Item 4.
This is a jail appeal against the judgment dated 17/12/24 passed by the additional session judge, special judge (POCSO, Barpita) in special POCSO case number 49 of 20, arising out of Howley PS case number 75/2020, by which the appellant has been convicted under section 6 of the POCSO Act. Admit the appeal, call for the TCR, issue notice, returnable in 4 weeks.
Not.
Uh,
Mr. B. N. Gogoi.
Wait, let's see. Mr. R. Sharma? Mr. R. Sharma is appointed as the amicus
Not.
curiae for the appellant. You give again to Ms. S. Sharma. Again, give her legal aid. Number 2. For respond number 2. That way it becomes easier.
Lordship.
Item 5.
Jail appeal. Lordship.
Okay, this is a jail appeal against the judgment dated ten 6/2025, passed by the Court of the Additional Session Judge, FTC, Sibsagar, in the sessions case number 221 (S-N) 2017, arising out of Nazira PS case number 187 of 2016, by which the appellants have been convicted under section 302/149. And 147, no, 149 IP. They have also been convicted under section 147 and 148.
Already appealed.
Admit the appeal, call for the TCR. Miss S.H. Bora, additional PP accept notice on the other state. This is the matter of the court. Again.
Amicus curiae.
I mean, so we have given, he's got many cases like this. There's new one.
MS M. Burman.
He doesn't have.
She is not present today.
No, let us spread it out.
She can go for it.
Again, he doesn't have many cases.
She's having cases, but she's good.
He's good.
One B. N. Gogoi is also there.
BN.
Mr. B. N. Gogoi.
But
Vivekananda.
who do you want? M. Burman. Okay, Miss M. Miss.
M. Burman.
M. Miss or Mr.
Miss
Miss
MS.
M. Burman is appointed the amicus. Yeah. Miss M. Burman is appointed amicus. This is the matter after.
Of last.
Lordship,
Mister, what's your name?
P. Khatania, Lordship.
P. Khatania.
Yes.
I heard Mr. P. Khatania, learned counsel for the appellant, who submits that the appellant has been convicted under section
302.
2 IPC by judgment dated
28. 28 2025.
308.
08/2025,
Five.
passed by the court of the
Session just Hemaj.
Sessions Judge Demaji
Demaji.
in Sessions Case number 57 of 2021. Admit the appeal, call for the PCR. Ms. S.A. Vora. Additional PP accepts notice on behalf of the state. This is the matter of the
Lordship,
There's IA.
Lordship, no. Lordship, the date reference has already been admitted by this honorable court and it is fixed on 8/12/2025, Your Lordship. I have this order.
This is. So this has to go to the same court.
Lordship.
Chief Justice.
Chief Justice,
Bench, Lord.
Division
Chief
Bench,
Justice.
Chief Justice, Your Lordship.
Okay.
Honorable Justice.
Don't say call for the PCR, don't say that. The counsel for the appellant submits that. Out here also, this person has been, given death sentence.
Yes, Lordship.
The appellant's counsel submits that by the impugned judgment, the appellant here has been awarded the death
This
sentence
sentence.
along with
Lordship, under 302.
no, along with whom? With whom? Only herself.
No, souls.
He's the sole appellant.
Soul appellant, Your Lordship.
Then what do you mean death reference is there?
Lordship, kindly go through the order dated 1/11/2025.
Good to have. No, so Rintu Sharma. Okay. The learned APP has brought to our notice the order dated 1/11/2025. Pass in the death sentence reference 1 of 2025. Wherein the matter is to be listed before DB1.
Division.
Registry to accordingly list this matter along with death sentence reference 1 of 2020.
That is fixed on 8/12.
That is fixed on
12.
8/12/2020. No, they have both only them two. Is this a Miss S.H. Bora, additional PP submits, no say additional PP only.
All right.
It's your plan, simply there, I think. This I have this.
7 orders.
Lordship, notice is served, Lordship.
On the last date, Lordship, the OC came for his personal appearance, but the notice has been served. So amicus needs to be appointed. It's a 2022.
Not required.
No,
If-
POXO Act, Lordship, that is
Where does it say that they have to be appointed?
DP applied.
Maple Lordship. But in this case, the appeal is admitted and the opposite party has not come up before this court. When the matter was in delay condition and limitation was filed, that time the notice was served to the opposite party to inform it income. Thereafter, since 2020, in main appeal also steps was taken.
Okay, so in the, even
Allowed to serve the notice to respondent number 2. 14/7/2020. Service
in seven,
2025.
I don't, 14/7 is not that is a office note.
Yes, my lord.
Notice has been issued.
Yes, my lord.
Yes, what has happened to this point number 2?
Lordship will take instruction, okay?
Okay, right. As people, as TCR has arrived, registry to prepare the paper book. Yes, Musa. Miss S. H. Bora, additional people shall appear a report with regard to the service of notice upon the respondent number to the OC of the Morrigan Police Station. List the matter on when?
Lordship, any date? First week of December.
December, give it after some time. No,
Yeah.
December only, but give after some time. 16, 17 or something.
17.
Also, please.
Highly okay.
Yes, Your Lordship, can it be passed over for some time? Senior is in legs.
I'll take someone someday. Yes,
Yes, it is.
Lordship, because already objection is filed, Lordship. The paper,
Not
the paper,
expired, madam.
then Lordship, because it is.
Love
possible-
affair.
Hmm.
There's a love
Comment
affair.
is there. Lordship.
Huh?
I love affair, Lordship. Love affair.
See, let
Yeah, it
us-
can be disposed of, Lordship.
that is what, let us see.
Lordship.
Where is the evidence?
PW1 is a victim, Lordship.
PW1 is a victim.
Depose in her evidence that she knows, I will start. She knows accused number 1 that the incident took place.
Counsel for the petition applicant to submit that there's delay of 15 days.
Lordship.
In filing the appeal against the conviction of the applicant and under section 6 of the POCSO Act.
Lordship.
And Miss S.H. Bora, additional PP submits that she has got no objection to the delay being permitted. Accordingly, the delay is condoned, registry to list the appeal. I is accordingly disposed of.
Obliged.
My please, Your Lordship. Lordship, as per last order, Your Lordship, I provide the correct address, Your Lordship. Thereafter, I call my client, Your Lordship. She also communicated at West Bengal, Your Lordship, that the earlier address is correct, Your Lordship, but why the postal answer received notice returned, I don't know, Your Lordship. Because in trial court, Your Lordship, on that address service was completed. Your Lordship.
Or you were the petitioner.
Yes, Your Lordship. I am wife, I am the petitioner.
You were petitioner. You applied for divorce decree.
Lordship.
You applied for a divorce decree, correct?
Lordship, decree for divorce. That was
And
passed,
that was dismissed.
dismissed, ex parte.
Ex parte actually, and imagine ex parte also you lost.
Lordship.
Imagine if she was there, if the other side was. There's no ex parte, he was there. Ex parte means that the other side was not.
That is,
So you lost your case even without any opponent being there.
Lordship.
So it's like this, you are going to a boxing match. You are one and the other side does not turn up, but you still lose the match. Huh? In the boxing match, you go to a boxing match, your opponent doesn't turn up, but you still lose the boxing match. Correct?
Lordship. In lower court, Your Lordship, trial court, Your Lordship, not considered the evidence and other grounds. Your
Let us
Lordship,
see the evidence. I think let us see the case.
31 days delay, Your Lordship, in this Your Lordship.
Oh,
That
that's
period
good.
may kindly condone, Your Lordship.
Then the problem is the matter appeal. Huh? He said- Yes, madam.
Lordship, in the earlier occasion, Status report was called for through registry. That has been received.
You see, one thing I have noticed out here
Lordship.
in the status report,
Yes.
this,
One of the co-accused was shown as absconder in the charge sheet, Lordship.
correct.
And thereafter,
That's why no trail has,
no trial has been
but then
initiated.
you come in,
Be split up, Lordship.
huh?
It can be split up, Lordship.
That's what, you come to this order, you come to page,
Lordship.
you come to page. Page 53.
Lordship.
And now you see, this is the rejection of the bail.
Lordship.
Now, this issue was taken up by this court
Lordship.
at
Page, last page, Lordship.
yes,
Starts from,
page 45, at 74.
yes,
Para-
73.
There are para 74, 45.
Yes, Lordship. There is a strict
Yes, please read. Please
Lordship,
read.
page 45,
Ah,
paragraph
45.
45. The above being said, the trial court is directed to proceed with the trial of the case, even in the absence of the absconding co-accused, in terms of the section 350C BNSS, after taking steps for declaring the absconding co-accused as a proclaimed offender under section 84 BNSS. There is a specific direction otherwise from this.
Correct. Now, now, this is in June. Why is he not taking steps? That's what I.
Lordship, that is what.
Yes, madam, what have you got to say? Has this order been communicated to the court below?
Lordship, the co-accused has already been granted bail, Lordship. I can say annexure G, page 36. Both accused were found with 1 kg of suspected heroin, Lordship. Together they had 1 kg.
No, we're just asking about the absconder co-accused. The investigating agency has apprehended 3 persons, Lordship.
So who has been granted bail when? On 26/3.
Yes, Lordship. Page 38.
Out of 3, Lordship.
Okay, we'll see this, but I'm going to call this thing. This magistrate.
In spite of specific direction from this honorable court, Lordship.
We'll take up your matter, we'll see.
Lordship.
Matter. Huh? This is the, which court is this?
Lordship, it's CJM Kamrup Metro.
Special Judge
Special
NDPS,
District Metro.
Kamrup Metro, Guwahati.
Yes, Lordship. Special Judge NDPS Kamrup Metro.
A Special Judge NDPS, Kamrup Metro, Guwahati. Tell them to, let this judge come and meet me at 1:30. Okay, what about the bail? She says that,
Ground of arrest,
no, she says that,
long incarceration and ground of arrest not given.
so the co-accused has been released on bail.
Lordship, the petitioner has already spent 3 years in jail.
Only?
He's only 20 years old.
So what?
And the punishment is 20 years.
So? That cannot be a ground.
Yes.
The only ground is parity.
Parity.
Consider the length of detention, Lordship, on
Length?
any condition.
No, Supreme Court now has said there's the latest judgment of the Supreme
Yes,
Court,
Lordship.
which says that length of incarceration is not the issue.
Yes.
That conditions required under section 37 are still required to be
Strictly
has to be fulfilled. But of course, there is a provision in the CRPC
Yes, Lordship.
and that 436A.
Yes.
Read with that is same as 479 BNSS, which provides that where a person has undergone half of the maximum sentence,
Lordship.
then he's entitled to bail. That they are not even half, 3 years is not half of
Lordship.
20 years.
Yes.
So you cannot be. Only thing is that with regard to parity,
Yes.
why shouldn't he be released on bail?
Parity order to put something into bail order to. 15.
Any judgment on
Lordship, also no grounds of arrest mentioned in the notice under.
No, Miss Madam, I am asking you a question. I am asking you whether you have had oranges. You are saying, no, look, the apples are much better. I am not asking you about apples, I am asking about oranges. So you stick to the question. Don't give me a different answer. It's like I'm saying, have you gone to Shillong? And you're saying, you know, I went to I went to the Brahmaputra River for a boat ride. That's not the answer I want. What to do, madam? Parity, one person already out. This issue was not taken up in the last.
Last.
When I in the last order which dismissed the bail application,
Lordship.
was this factor taken up by the council, earlier council? No. Was it taken up, madam?
No, Lordship. Perhaps no.
Turn to page 53 of your petition. 53. You have got a senior?
No.
Oh, yeah, okay. They are risking. Risk. Good. Sometimes you have got to take a risk. How many years have you practiced, madam?
2 years. Lordship.
2 years. Okay. Good. And
Lordship, 55 page.
55.
Only they have taken the ground that the petitioner should be released on bail due to his long incarceration.
That's what. They did not take up this issue.
Yes.
So maybe she has got a chance. It's a new ground.
Yes.
Uh, Where is the bail given to this person?
It
Starts from page.
38.
Starts from page 38.
30?
38.
Yeah. Oh, wait. Madam. Sorry, this Majibur Rahman, nothing was seized from him.
Yes, Lordship.
Nothing was recovered from him.
Yes. The said two persons were Abud Ahmed and Ubaidur Rahman, the present petitioner. Those contrabands were recovered from from the present petitioners along with the co-accused Abud Ahmed. So present petitioner is not the person from whom the contraband has been seized.
What has happened to Abud Ahmed? What we do is, why don't you find out what has happened to Abud Ahmed? Has Abud Ahmed been given bail? If he has been given bail, Abud Ahmed, then we will grant you bail. When do we release this matter? When do you want?
December, let's say.
In the month of January also.
No, not that. As fast. As fast as possible. When?
Lordship. 16
Yeah,
December.
can you find out? In this case. When I think there was a- No, whether what is even did this Abud Ahmed in this NDPS case number
60
of
of 23. 60 of 23. Kamrup Mehta.
This case from the same person.
Abud
Abud
Ahmed.
Ahmed. This is corresponding to Guwahati GRPS case number 163 of 23. 2020. Pertains to Abud
Ahmed.
ABUD Ahmed. This bail application is there. Pertaining to heroin. 1 kg of heroin. That person is coming anyway. I think where the information. I will take up at 2. Difficult, madam, very difficult. This is a serious case. Heroin.
1 kg.
2 o'clock.
Not sure. Next.
Let this matter come, let this file be sent to me. Yes, anything?
Lordship, I have found the status of the co-accused, Abud Ahmed, Lordship. He is also in jail.
He is in jail. And Lordship, I'd like to refer one judgment of the Supreme Court that is decided in Lordship, paragraph 4, paragraph 5 and 6, Lordship.
Yes.
May I read?
Yes.
Learned Additional Solicitor General for the state submits that the High Court has not provided justification for waiver of mandatory condition under
Wait,
section
wait, wait, with me.
37 is
It starts from. Acha.
Yes.
It's.
SLP,
How is it?
SLP arising out of criminal
There's this.
number 9792/2025. It was so. Para 2, 4, 5 and 6. 5 and 6. And last paragraph, findings.
Why don't I have that? No, she doesn't have, no, now.
May I read, Lordship,
Yes,
if your Lordship. gives
that's
me.
what.
Here the recovery was ganja, Lordship, 731.075 kg. Here, and the learned additional Solicitor General for the state submits that the High Court has not provided justification for waiver of mandatory condition under Section 37 of the NDPS Act. In support of his submission, he relied on the judgment in narcotic NCB versus Kasif 2024, whereby the Supreme Court has held that paragraph 8, there has been consistent and persistent view of this court that in the NDPS cases where the offenses is punishable with minimum sentence of 10 years, the accused shall generally be not released on bail. Negation of bail is the rule and its grant is an exception. While considering the application for bail, the court has to bear in mind the provisions of Section 37 of the NDPS Act, which are mandatory in nature. Recording of the finding as mandated in Section 37 is a sine qua non for granting bail to the accused involved in the offenses under the said act. The upshot of the above discussion may be summarized as under the provisions of NDPS Act are required to be interpreted keeping in mind the scheme, object, and purpose of the Act, as also the impact on the society as a whole. It has to be interpreted literally and not liberally, which may ultimately frustrate the object, purpose, and preamble of the Act. Roman 2, while considering the application for bail, the court must bear in mind the provisions of Section 37 of the NDPS Act, which are mandatory in nature. Recording of findings as mandated in Section 37 is sine qua non, is known for granting bail to the accused involved in the offences under NDPS Act. Learned Additional Solicitor General also contends that in view of the sections of NDPS Act attracted to the present case, respondent accused is liable to be sentenced to a minimum terms of 10 years, with the maximum term being 20 years. Paragraph 5 and 6.
Yes, madam.
And paragraph 13 is relevant.
13.
Yes. Moreover, this court is of the view that as the accused has been charged with offences punishable with 10 to 20 years rigorous imprisonment, it cannot be said that the respondent has been incarcerated for an unreasonably long time.
So out here, how long were they in jail?
3 years, Lordship, in the present case.
No, out here in this case.
In this case, 1.5 years.
Yes, madam. What's your submission? Let's hear you.
Half of the punishment is also 10 years.
Huh?
Half of the punishment is also 10 years.
So how many, so this is, what is the minimum punishment that can be given to you? In this case?
Maximum.
I'm asking her, what is the minimum punishment that can be given to you? Supposing you are found guilty. How much? Any idea? No. No. Oh, this is, you have been charged under which section?
20C, Lordship.
20B to C.
Yes.
Is it?
Mm.
No, let us.
21C.
Huh?
21C.
21C. Okay, heroin, no? Now, what is the punishment for 21C? Have you got the act with you?
Years.
Huh?
20 years.
Minimum. The minimum or maximum? Give her the NDPS Act. Madam,
Not
when you
less
come,
than 10 years.
you should come prepared.
20 years.
This is the law. Look at 21C.
Not less than 10 years.
21C.
Oh, no, let her look, let her look, let her learn to open the pages.
Not less than 10 years, Lordship.
Yeah, read 21C. According to you, not less than 10 years. Let us see what the law says. (21C). What? Louder, louder. We can't hear you.
20 years, Lordship, and shall also be liable to fine.
20 years is minimum.
Yes, Lordship.
Oh, so not 10 years.
Not less than 10 years, but which may extend to 20 years.
And you're asking for bail on what ground? One co-accused, that co-accused, nothing was recovered from him. Any other ground? Any other ground, madam? No. When did you start practicing?
2 years ago, Lordship.
2 years. Okay. You are who's junior?
Mr. K. Borwa.
K.
Borwa.
Borwa. So this is not Mr. Barwa's case, correct?
Yes, Lord.
It's your case. Your case.
Yes, Lord.
Good, good. So it's a risk. But you should read. You should read a little. Three years. You don't have any judgments with you?
No, Lordship.
No. Have you seen the early orders passed by this court?
Lordship.
Have you seen the earlier orders passed by this court rejecting the bail? No. You've seen? There are some judgments there. That's all? Heard Miss
P. Das.
P. Das, Learned Counsel for the applicant. Who is Miss Buyan? Who is Buyan?
She's my friend.
She's your friend. Group of friends are trying their luck. We could have granted, but it's
1 kg of
1 kg of heroin is a bit too high.
No.
If it's heroin, it's a bit too high. What was it? Miss P. Das, Learned Counsel for the applicant. Also heard Miss S.H. Bora, additional PP. This is an application for bail. In relation to the seizure of 1 kg of heroin that had been recovered from the petitioner and co-accused Abud Ahmed on 19/11/2020. Both the above two persons had apparently been arrested with half a kg of heroin each from a train. Another co-accused, that is MD Majibur Rahman, had been arrested on the basis of the statements made by the petitioner and co-accused Abud Ahmed. Next paragraph. The petitioner's counsel submit that as MD Majibur Rahman has been granted bail while order dated 5/1/24 passed in bail application number 2479/2023. The petitioner, who is a co-accused, should also be granted bail. That's all. That's all you. What other ground have you taken? That's all. That's one ground only. Any other ground? Any other ground? No other ground.
No, Lordship. On a length of detention, if
Okay.
it's possible. Lordship.
Okay, then right. The petitioner's counsel further submits that the petitioner, having been in judicial custody for more than 3 years, and as the trial has not started till date, the petition should be granted bail. Correct? Any other ground?
No, Lordship.
Those two grounds only.
Yes.
But those two grounds have been already decided. But anyway, there is one thing. Okay, right. Miss so-and-so, done an additional people. Submits that the statement that submits that the MD Majibur Rahman had been granted bail by this court in view of the fact that no heroin had been seized from him. Further, MD Majibur Rahman having been arrested on the statements made by the co-accused, the statement made by the co-accused, which were not admissible in evidence. The release of bail of MD Majibur Rahman could not be said, cannot have an effect on the plea for bail made by the petitioner here. The learned APP further submits that in terms of the order dated 7/11/2025 passed by the Supreme Court in the case of Union of India versus Namdeo Ashruba Nakade, arising out of in SLP criminal number 9792 of 2025, wherein it has been held
Paragraph 5 also.
not wherein you cut that, which has observed another of his judgment in the case of Narcotics Control Bureau versus Kashif 2024 SEC Online SC 3848. Wherein it has been held that while considering an application for bail, the court has to bear in mind the provisions of Section 37 of NDPS Act, which are mandatory in nature. So further, the recording of a finding as mandated in Section 37 is a sine qua non for granting bail to the accused involved in an offense under the Act, under the NDPS Act. I have heard the learned causes for the court. As can be seen from the fact of this case, the applicant was arrested in connection with, the co-accused, Abud, what was his name? Abud,
Ahmed.
Abud Ahmed,
Abud
Ahmed,
Ahmed.
Abud Ahmed, for possessing half a kg of heroin each. The applicant has been in jail for more than 3 years, in as much as he had been arrested on
1911. 1911.
1911, no, 2011, 2020.
Date of forwarding is 2011. Lordship arrested on 1911.
Arrest memo was 2011.
Forwarding is 2011.
Okay, 1911, 2020. Today. First time. It is also noticed that the earlier 4 bail applications of the petition, that is bail application number 956 of 2024, 1527 of 2024, 1709 of 2024, and 1731 of 2025 had been rejected by this. On considering the fact that No, let's go. The co-accused Abu Ahmed had been released on bail. As no,
Abu Dhabi.
Yes.
no, not Abu Ahmed, Majibur Rahman.
Sorry.
Majibur Rahman had been released on bail as no drugs were seized. No drugs were recovered from the possession of MD Majibur Rahman. With regard to the issuance of, with regard to the trial not have been started by the learned trial court, it has come to the knowledge of this court that notices have been issued for declaring the absconding MD Majibur Rahman.
MD Hussein Ahmed, Lordship. He is an
Majibur Rahman,
absconder.
Majibur Rahman, madam. Hussein Ahmed.
Hussein Ahmed is an absconder, Lordship.
Okay. What about Majibur Rahman? Who is he? He been acquitted, discharged?
Yes, Lordship.
Huh?
Granted bail, Lordship. as well.
Majibur is a co-accused who has been granted
Granted
bail
bail.
from whose possession nothing was recovered.
Okay, so for him,
Yes.
he's not absconding.
No, Lordship.
The one who's absconding is
Hussein Ahmed. Hussein Ahmed.
Hussein Ahmed.
okay. So what have I said? Has been issued with respect to the absconder MD Hussein Ahmed. By way of to be published in a national and in a local daily newspaper, circulating in the last known address of the said MD Hussein Ahmed. Now, wide order dated 12/11/25, passed by the Session Judge Kamrup M. Assam. But the above appears to be in consonance with the order dated 24/6/25, passed in bail application 1371 of 2025. One three seven one of 2025. Wherein this court had directed the trial court to proceed with the trial, even in the absence of the absconding co-accused, in terms of section 350C, capital C, BNS. As has been pointed out by the learned APP, the Supreme Court in the case of Namdeo Ashruba Nakade Supra has held that the provisions of section 37 of the NDPS has to be followed while considering an application for bail. Where the minimum sentence is of 10 years. In the present case, I am unable to come to a finding that the applicant, is not guilty of the offense. I am of the prima facie view that the applicant is not guilty of the offense for which he is being charged. The minimum sentence that can be inflicted in the event of conviction of the applicant would be 20 years. And in view of the same, not full stop, in view of the reasons stated above, this court is of the view that bail cannot be allowed at this stage.
My dear.
The bail application according to this.
Obviously.
Let's see next year.
Lordship, here minimum is not less than 10 years, which makes 10 to 20 years.
Our minimum is 10 years,
Not less than 10
not
years,
20.
which makes 10 to 20.
She was saying 20.
Not less than 10.
Let's see if the trial starts from next time.
Lordship. That has to be expedited or split up, Lordship, if he is found.
It should be split up. The order is there. If it is not split up, then maybe I do not know if the client will still hire you though. And try your luck maybe next week.
Highly of that.